Ready, start. After the order of dismissal, the union is stated to have extended financial assistance of approximately rupees 10 lakh to the petitioner on December 19, 2014, subject to the condition that the said amount would be repaid in the event the petitioner succeeded in challenging his dismissal before the competent court. It was also pleaded that after the termination, the petitioner remained unemployed for 2 years para. Thereafter, he had set up a grocery shop. According to the petitioner, the said business had suffered losses and was closed on November 20, 2021, and since after that he is without any gainful employment para. The petitioner thereafter instituted complaint before the Industrial Tribunal, Pune, under Section 33A of the Industrial Dispute Act 1947, challenging the order of dismissal as arbitrary, illegal, and unsustainable, and seeking reinstatement with consequential back wages. The termination was assailed principally on the ground that the findings recorded by the inquiry officer was perverse and that the domestic inquiry was neither fair nor proper. A further challenge was raised on the ground of discriminatory treatment. It was contended that 13 similarly situated workmen were inflicted only a minor punishment of 4 days suspension, whereas the petitioner, though allegedly on the same footing, was visited with the extreme penalty of dismissal para. Under the said order, the tribunal held that the domestic inquiry held against the petitioner was fair and proper, and further held that the findings recorded by the inquiry officer could not be termed as perverse para. Thus, the challenge to the legality of the inquiry and to the evidentiary basis of the findings did not find favor at that stage para. The High Court has pointed out that the observation of Supreme Court that nothing more is required to be done by workman means he did not undergo second round of litigation for reinstatement when the act treats such dismissal as non-east. Once breach is established, consequence follows by operation of law. Employee is not required to seek declaration of status which already stands protected under statute. If employer is action never acquired validity, then interruption caused by such action cannot be allowed to prejudice the employee para. For the period after closure of grocery shop during COVID time until reinstatement, the workman again appears to have remained without livelihood para. In absence of proof of alternate employment, thereafter he cannot be denied wages for that period. According to the High Court, balancing equities grant of part of back wages is proper para. The complainant is entitled to full back wages from the date of termination till commencement of grocery shop in 2016, 50% back wages from 2016 till closure of grocery shop during COVID period, and full back wages thereafter till date of reinstatement. The High Court has dismissed the writ petition filed by the petitioner company. The High Court has partly allowed the writ petition filed by the petitioner workman para. The High Court has upheld the award passed by the Industrial Court, Thane, on January 18, 2024, to the extent it holds that termination of the workman was affected during pendency of the references and was in contravention of Section 33(2)(b) of the Industrial Dispute Act 1947. The High Court has set aside the said award to the limited extent whereby the Industrial Court denied relief of reinstatement with back wages and had granted compensation of rupees 7 lakh in lieu thereof para. The High Court has declared the order of termination dismissal of October 17, 2014 inoperative and unsustainable in law. The court has directed the respondent company to reinstate the workman in service to the original post or to an equivalent post carrying same pay scale, status and service benefits within 8 weeks from the date of this order with continuity of service for all purposes and back wages as stipulated. Arrears payable are to be paid in 12 weeks from the date of reinstatement.